So, Renato, is special counsel Jack Smith finally in the endgame of the Mar-A-Lago case?
Eh, it's complicated. I'm Renato Mariotti. I'm a former federal prosecutor, a practicing lawyer, and a legal analyst.
And I'm Asha Rangappa. I teach national security law at Yale University. I'm a former FBI special agent, and I'm a legal and national security analyst.
And we're here to help you understand topics that can't be boiled down into a soundbite or a tweet.
Okay, so the scuttlebutt on the street this past week is that special counsel Jack Smith is ready to indict Trump. And this is because his camp leaked a letter that they wrote to Attorney General Merrick Garland asking for an audience with him to, I guess, make their case on why he shouldn't be indicted. And so I think it was deduced that, I guess, maybe that he somehow received a target letter or otherwise had been informed that an indictment was imminent. And I'm wondering whether you think that's the correct interpretation or if this is another psyop by Trump, because, of course, we know that in New York, he also claimed that he was just about to be indicted and he really wasn't.
So, first of all, I got to say, Asha, that letter does not resemble anything I've ever seen in terms of communications with the prosecutor before. It's more like a truth social truth, kind of with letterhead around it, rather than an actual communication. So,
I was surprised it wasn't in all caps.
yeah, right. There's no exclamation points. But yeah, it was a little bizarre. It is very commonplace. In fact, it is, I would say, expected that before a defendant is charged by a prosecutor, the prosecutor usually lets the defense attorney know. Defense attorneys usually come in and they make what's called a pitch to some sort of group of supervisors in that office to basically try to convince them that actually they're making a big mistake and that their guy doesn't deserve to be charged and there's all these things they're missing and so on and so forth. It does not always happen. I had a case that was prosecuted by Maine Justice, and I told them my client was innocent, and they didn't want to talk to him. I don't always let you talk to me about it. It's very bizarre. So it does happen from time to time where they're like, "Yeah, we don't care about what you have to say," but usually, customarily, that happens.
And is that like a formality? Because I kind of feel like if the Justice Department is at the point of indicting, they have at that point amassed a lot of evidence. So, in other words, what could possibly happen in that conversation at the 11th hour where they're like, oh, yeah, you're right. You're right. We're just, this would just be taking it too far. Or we got it wrong or something like that. In other words, what would there be some smoking gun that the defendant comes forward with? Or what would persuade the Justice Department to not follow through at that stage?
Smart question. A very good question. You're right. It's usually a long shot, Ash. I agree with you. But there's a few things that can change, be game changers. So one thing is that this is often the first opportunity that the defense has to speak with some supervisor, somebody who's not the attorneys who are working the case. And sometimes the attorneys working the case are zealous. They have a few of the facts that's slanted, and the defense can convince the supervisory chain that, like, this case is a lot tougher than you think. Like, you're going to have a very difficult trial on your hands. Like, Asha's fantastic, but the way she's describing the evidence is not quite right. Like, she's missed this piece here or that, or, while we respect her view of this. So you do that sort of thing, that can be a real game changer. And often what that just does is it delays the inevitable. They end up coming back with a slightly altered set of charges, or they go get more evidence. And, that often makes the defense mad, but that's often the result there. But that can be at times a big game changer. Sometimes the defense will come up with a potential resolution in in concert with that, where they'll say, "Look, I understand that you think that my guy who showed up to with $1 million in cash, was actually trying to launder drug proceeds, but actually he thought that he was evading currency reporting requirements. Here's a different crime that's got lower penalties that we think is a more appropriate plea, and the evidence fits or whatever, something like that. But often, most of the time, these pitches are, my client's a fantastic person. Donald Trump has got great charitable foundation. He's a great father. He's very old. He's going to die in prison. All of these things, and it doesn't persuade anybody. That's usually how these go. But you have to kind of go through the motions to take your shot, anyways. It's like play the lottery or something, just in case.
And that makes sense for the ordinary defendant. One assumes, however, that the Justice Department may have taken into account all of in other words, the former president of the United States likely has already gotten all of the benefit of the doubt in terms of all of the reasons to not charge him, unlike your ordinary defendant, because of just the uphill battle that it is on his face because of who he is. And as you said, that letter is just weird. And it looks performative to me and not like a genuine attempt to somehow make a case to prosecutors.
What a fancy lawyer word, performative. That's how we know you went to the Yale Law School, Asha.
Acting,
Um,
yeah.
yes. So yes, but it's more meant to send a signal, perhaps his donors or his supporters or whatever. I think that's potentially correct. I've also heard rumblings. I mean, I can't reveal. I mean, I don't know about you, but I've been getting calls, off the record calls from various reporters and so on. My understanding is, I could be wrong, but my understanding from what I hear is that this was not prompted by a specific communication from Smith, where like Smith did not say like, "Hey, come on and make a pitch," which often happens. Like, "Hey, we're going to indict you in 2 weeks if now's the time." He didn't do that, so I do think that this was, there's some freaking out internally in Trump world. And I will note there was an interesting article in Rolling Stone, which has had like a number of scoops from within the
I was
Trump legal camp.
yeah, they have. Uh-huh.
They clearly got some mole in there, like there's some
Right.
paralegal who loves Rolling Stone. Maybe he's getting a signed guitar or something in exchange for some tips. But in any event, they said that Trump's lawyers have informed him that he is going to be indicted, right? And then we also saw one of his lawyers quit, which is sort of like there was having some difference of opinion. My understanding is that there are some people in the Trump camp who are convinced he's not going to get charged, but those are mostly clowns who don't know anything about criminal law, and that the dominant uh, group there is convinced he's going to be charged, which I think is consistent with everything you and I know. Um, if there was going to be a game changer, I mean, one thing I will just say, I mean, I have been out there. Oh, I don't know if I'm over my skis or right above them, saying I think he's going to get indicted by Jack Smith for this Mar-A-Lago thing, which is a new territory for me to be in. I'm rarely ahead of the game on that stuff. I'm usually pretty cautious, but there's so much pointing to that, and the evidence looks so strong. But I will say, though, this is a special case, as you point out, Asha. I mean, if he doesn't, it's purely because of something that's very unique to the president. I doubt that's the case here, but you never know. If there was going to be some move by Trump that was going to derail things, I actually think it would be come in one of two categories. Either some unconsidered evidence or defense that, like, wow, like, we actually have videotape of him back in, 2020 moving his hand and saying this is all declassified, or he sent a bunch of contemporaneous, letters saying that, or like we're going to come in and do it. We're willing to do a plea to X, but not Y, and like that might blow somebody's mind. Like we're willing to plead to anything. Like I think Jack Smith would have to seriously consider that, but I don't think any of those things are going to happen. I think he's going to get charged. He's going to delay this until after the election. We know that the Manhattan DA case is going to be tried in March. I can't imagine of 2024. So I just can't imagine that this goes before that. And realistically, It'll probably be after the election.
And what do you think the charges might be? Just obstruction, or do you think Espionage Act also?
I think there will be, yeah, I think there are going to be crimes related to the willful retention of defense material as well, for sure. I don't see what Smith. I know that some people have said that it's cleaner, it's better to focus on the obstruction. I think he'll just use that as, he'll make that a very centerpiece of the indictment, and I think that will certainly be central to the conspiracy. But I would be surprised if he doesn't include charges related to the willful retention of classified material. And one thing I just want to say, because there's a lot of people who are like, either I've seen some comments like, I'll believe it when I see it, or he's already indicted. There is such a gulf of difference between the Manhattan DA case and this case. Like as a criminal defense attorney, I don't really. The Manhattan DA case is like an kind of case. It's the lowest level of felony. All my friends who practice in Manhattan are like, he's not even going to get prison time. No one would get prison time for that. It's kind of an uphill battle, and there's some oddities to it. I won't say uphill battle, but there's some challenges to it. The Jack Smith case is like the Justice Department, a really straightforward case, big time penalties. People go to prison for a long time for doing this. Pretty serious stuff.
Yeah, and it also seems like the that particular provision of the Espionage Act 793E, I think it is, 18 USC 793E, the willful retention, would dovetail with the obstruction, right? Because I think one of the elements is that the willful retention involves not turning over the documents after there has been a demand by an official for their return. In other words,
Yeah.
it's sort of like the obstruction in some ways is kind of baked into, or the willful retention, I guess, is baked into the obstruction part of it, if that makes
Yeah.
sense. So that does seem like it makes sense to me, because I always thought maybe he'll only charge obstruction as a way to very clearly distinguish it from the Biden or Pence or whatever situations where where they have discovered that they are in possession of classified information, right? Because those individuals clearly cooperated, turned it over, they're like, take it, come search, whatever. But I do think that particular provision of the Espionage Act sort of implies a certain level of, maybe not necessarily obstruction itself, but like defiance of the preventing the return of the information.
Yeah, and I just think the fact pattern here is so egregious in that regard. I mean, really, what the feature, if I was going to describe this, is just I think the Justice Department and FARA before that bent over backwards to treat Trump with kid gloves, and I think in the process of doing so, made the case very, very easy for Smith to prosecute. You got letters that went to Trump, a personal visit from the DOJ and FBI. Of course, as we know, I think we discussed this briefly last week. There was some movement of boxes maybe right before that visit, but there's that. And then obviously, there was the false affidavit or the affidavit containing false statements, and then a raid, right? An execution of a search warrant. I mean, a pretty amazing set of circumstances. So,
and then on top of that, after all of that, it's not like he's like, oh, I had no idea that was here. Like, he literally sued to keep it.
Yeah, I know. That was a really dumb move.
He literally sued to keep it. I think that was a really dumb move. And I wonder if that will show up as a part, like, yes, he was using legal process, but it was obviously like a completely, cockamamie legal theory that he was using, but he was explicitly arguing that they were his, that they were, I mean, didn't make sense. He was simultaneously arguing that they were subject to executive privilege and they were also his personal records. But in any case, and it seemed it was very desperately trying to retain them in some fashion.
Yeah, and I mean the special master went out of his way to require them for every single document to state, like they had to have a spreadsheet and they had to state, is this his personal property? Is this a presidential record? Like they had to take a position on a granular level for each document. And I think you got to think the Justice Department's going to argue that that precludes Trump from taking the opposite position later. I mean, they certainly at least have an argument. And I think it's just not where you want to be. I know at the time, my reaction was, as a defense attorney, I never want to take a position on anything until I see all the evidence, because you don't take your client's word for it on day one. Like, oh, sure, I know how everything plays out. No, you wait and see what the evidence looks like and take your position at the end. So yeah, they're in trouble with that. And I think the public statements by Trump are perhaps the most problematic. Interviews with Hannity, where he's just like, these were my documents and I could have shown them to people if I wanted to. And
Nixon got $60 million for him.
yeah, I could have declassified it with my mind and all of that. I mean, it just puts him in a spot. I mean, if I would seriously consider, if I was Smith, playing that tape just to make it hard for Trump not to take the stand.
Yeah.
If Trump doesn't take the stand, the jury is going to hear that and it's going to remind them that he didn't say anything, and that's going to be what they're left with. And it's just so bizarre.
Just imagine, like, in the Trump multiverse, where,
Multiverse? Is this like the Council of Trumps, like the Council of
well,
Kangs,
this is
the
like the
Council of
alternate
Trumps?
universe
Okay.
where the search warrant is executed. He never says anything.
Hmm.
Except tweeting that this was, and unfair, and maybe even like, I had no idea, like, I'm the president, like, I don't pack my boxes, like, who knew they were there, and just like never like fought it. It seems like this might have been a tougher battle.
Oh, a lot tougher. So if let's just say that we rewind and I took control, like Trump was lobotomized and just was sitting there and didn't do anything, and I was controlling the legal strategy on the day of the raid, then I would put out a statement, not him, me, saying, look, obviously there's a lot of boxes and lots of moving, parts coming out of the White House. He's got all these properties. He's only, he's not there all the time. He doesn't really know. And, he wants to resolve this. And, like, obviously, we shouldn't be, he's so, he's so disappointed that these things were found, but he wants to cooperate in any way he can. And he tried his best and that sort of thing. And, it would make it seem, just play the unfairness card. This is so unfair.
Exactly.
Now, but the reality is that a better time to morph, if we're going to do like the Back to the Future, like, and we're, I'm Biff or whatever, I'm going back. And if you're Biff, you want to go back to like when when the DOJ and FBI came the first time, because there any
With
competent,
the subpoena.
right, any competent lawyer is like, okay, we can't screw around here. We need to dig in. We need to search through everything. We can't play games. If you do, you're gonna end up going to prison, and I'm gonna go to prison with you. We're not doing that. And that happens. That's like a regular occurrence. So
Yeah.
people are like, "What do you do all the time?" Like, a lot of what I do is, big company gets a subpoena, and like some employee screwed it up, and it's like, okay, we got to call in Renato, and I'll come in, with some other lawyers, and it's like, okay, we're going to do this the right way, and placate the FBI or the SEC or whoever it is, and then we move on to the next case. That's what would have been a better time.
Well, and I think the fact that that didn't happen, I mean, some of it you can chalk up to Trump's personality, but I really do think, and, Andrew Weissman for a while was just tweeting this out, like, it's been 30 days, it's been 60 days, and we still don't know why he retained those documents. And I think that as time has gone on and he's engaged in all of these different maneuvers, insisted that they're his, like, you just like that, to the motive to me. And I know there are going to be listeners who are like, well, it's obvious he was going to sell it to the Saudis. I mean, maybe, I don't know, but it's just like, I would just love to get the real, like, I would love the Colonel Jessup moment.
That
where
never
he just
happens in real life,
I
Asha.
know, but I want it. I want it. Like, you know, God damn it, yeah, I sold it to the Saudis or whatever. Like, I want to hear it come out of his mouth. Like, I want to hear what he wanted to do with those, because he's not sentimental. Let's be honest. Like, he's not I mean, maybe with the Kim Jong Un love letters, possibly, but like with everything else, um, it's transactional. And I think that they're like, what did he want with it? Like, what did he expect was going to happen? And why was he so insistent on ensuring that they stayed in his possession?
All right, I'm gonna go back to my usual sad panda mode.
Mm.
And I'm gonna give you like here's like the Occam's razor, like to me, like the base level. Trump likes to feel important, likes to brag to people. Isn't it possible that he just had these kept these classified documents because they were cool, and he could show people at Mar-A-Lago, like, look at what I got. I was the president, and I can show you where all the nuclear
That can
bombs are.
explain
Wow.
that can explain, I think, the initial part. I don't think that explains the lengths to which he has gone to keep them in his possession.
You don't think it's just because he's like, who are these people telling me what to do? These are mine.
Maybe.
It's all
I don't
mine.
know. I
I
don't
don't
know.
know.
That doesn't
I go with eating chess pieces
I mean,
all the time with that
that's an
guy.
ego. That's the ego explanation. I mean, I feel like there has to be a greed or leverage piece here. And the greed is the obvious one, so people are like, oh, he's going to make money. But I think leverage is really important because, we know that many of these classified documents that he had were briefings of foreign leaders, like, which would have been really candid assessments of,
Hmm.
who, their weaknesses or vulnerabilities or whatever, our intelligence agencies might have assessed about them. And he is very attuned to that in terms of understanding what other people's Achilles heels are and how he can exploit them. And we saw this with, President Zelensky with
Right.
Ukraine, right? So I don't know. Like, I wish, I hope maybe after it all, like, he writes the If I Did It book.
Which, of course, is a great reference to O.J. Simpson, who wrote If I Did It. And then the dumbass chose to publish it, and the victim's family's like, hey, we should own that because we got $1 jillion judgment against you. So it ended up, that family published it. I think the Goldman family published it. And if you look at the cover of it, it says, I did it. And then there's a tiny if. Like, it's like so small. It's like microscopic. Okay. You can barely see the if. It's like, I did it by O.J. Simpson. Anyway. Yeah, I don't know. Well, that might. I could see that happening from prison. I mean, Trump would totally be the kind of person who would want to do like a live Zoom from his, prison cell and whatever, fire different prison guards or something. I don't know. Yeah, I don't know. I just think that guy, like, there's so much like three-dimensional and four-dimensional chess people ascribe to that guy, and I just think so much of it is just like him being a dumbass. Yeah, I mean, it's not even, it's like him eating the pieces. It's just like stupid stuff. And I think like he's survived this long because he does really novel, bizarre things that like don't fit within particular statutes, or he was the president and
Or social
or
norms
whatever.
or the law. Yeah.
Yeah, whatever, something goofy. And like, but now, like, he's found this is like something that is just so straightforward that he kind of effed himself. I don't know. Maybe I'm wrong. I just think he's so dumb about certain things. Like, he's clearly not a genius when it comes to legal strategy. I could be wrong, but we'll see.
We'll see.
So, Asha, I've heard now. I talked in the last segment about my super secret conversation that I've had with some journalists I can't
Mhm.
repeat. I've also have some my I have cone of silence is around me, but I have also heard rumors that you may be getting some new job soon. I heard something about that.
Yeah, a new gig,
A
shall
new
we say.
gig. A
A
new
new
gig.
gig. I'm still at Yale and I'll stay at Yale, but I may be returning to your screen um as a regular commentator. And I don't want to say anything just yet until the ink is dry, but I'm excited about it. It's always nice to have a home with, a network. And one of the things that I've been kind of doing and sort of on call for is to be ready to talk about the Supreme Court decisions that are being handed down. And there's, a number of them that are on deck. I was kind of I was like, wait, and it's hard because it's like I feel like a soccer goalie. You know what I mean? I'm because you don't know it's gonna come. It's like Thursday morning and they're dropping it. And I'm on SCOTUS blog just like waiting for like what's dropping. And there's a number of decisions. I mean, I think a couple of weeks ago it was like 44 that they still had to hand down, and now it's like in the mid 30s or something. And I mean, it's not that many that are national news focused, but there are
Right.
quite a number. And so, you're waiting for those. And so I just thought I could give like a quick rundown of what we're waiting to hear, and just like the cases, what the big issue is, whatever your thoughts are on it.
Yeah, there's some big ones. I
Yeah.
have thoughts on one in particular, or a group of ones in particular. But let's hear. So, what are you the most interested in this term? If it's not what I'm thinking of, I'm going to be surprised. I bet we're going to be on the same wavelength with this one.
I think I am right now most interested in the affirmative action case.
Okay, there you go. I was like the end of affirmative action, I
Yeah.
think. And don't you think that's inevitable at this point?
I think it's inevitable. I mean,
Right,
my question is right now just how the opinion will be worded. Like, in other words,
right.
what exactly it will proscribe, not whether it's, I mean, I think it's pretty much a fait accompli that it's going to proscribe it. This is Students for Fair Admissions versus Harvard um, and UNC. They're basically two different cases. The UNC case is a 14th Amendment challenge that the consideration of race violates the Equal Protection Clause, and the Harvard case is based on Title VI of the Civil Rights Act.
And I should note there's obviously an important difference between those two institutions because UNC is a state school, so the government that's
Correct.
engaging in this activity versus Harvard's a private institution. And you know, governments, they have to be more careful about making decisions that take into account things like race, gender, etc. Private institutions usually have a lot more freedom to do that. But it's interesting. I mean, I know a lot about the Harvard case because my co-clerk, it was the lead it was the lead trial lawyer for that case, a
Oh, wow.
right wing lawyer so I've been heard about that case for years from him. And this is a kind of right wing activism. When you and I were in law school, Asha, we heard all these stories about impact litigation in the 50s and 60s that amazing lawyers like Thurgood Marshall or Ruth Bader Ginsburg and others brought to move rights forward and make our society more inclusive. This is sort of the opposite, right? The right doing this, sort of like some of the impact stuff that they were doing on the abortion front, similar.
Yeah, I was just saying, like, this is about, like, the abortion litigation is to reverse some of the, in my opinion, the progress that was made during the 60s and 70s on things like reproductive rights and civil rights and all of that stuff. This would clearly upend, existing jurisprudence and how schools consider race and admissions. The precedent here is Grutter versus Bollinger, which is a 2003 case that held that University of Michigan could use race as a part of an effort to create a diverse student body, that it could be one factor that could be considered. And interestingly, Sandra Day O'Connor in that case says somewhere in there in the dicta that this kind of consideration won't be necessary in 25 years. So it's, we're
Yeah.
19 years later, and I suspect that that will come back to haunt this case in some ways, like that somehow we're post-racial and it's not necessary maybe, or and for sure that this idea of considering race is itself. And what's really interesting here is I was reading I didn't listen to the oral arguments at the time, but I was reading kind of the breakdown of the discussion. And it does get to like these intangibles of like, how do you define diversity? How do you know when it's been achieved? Um, and really, this, and there's another case later that I'll mention about the Voting Rights Act. When you're looking at something like the 14th Amendment, which bars the consideration of race, those can also be thought of as sort of affirmative action amendments, right? I mean, they were amendments that were trying to, and this is the 13th, 14th, and 15th, all these Reconstruction amendments, were trying to correct for the racial inequality and disparity that existed at the time. And so there is like a question of whether, are these really race blind? Like, is the 14th Amendment truly asking for something race blind, or is it actually, contemplating some sort of corrective action? I don't know. And I think that's just a very different approach to how you view that, the idea of equal protection, given when it was passed and what it was trying to do.
Right. It certainly was a very massive effort in Reconstruction to try to take affirmative steps to undo, obviously, massive subjugation and inequality and harm that was done. But of course, it was cut short very quickly. I will say too, that one of the things that is unfortunate here is, I think, some of the facts with Harvard. Harvard, I think, in terms of some, you're saying you were a former admissions person yourself. They had a lot of internal statements and communications about Asian Americans that I think were unfortunate, and that made the trial record such that and I think it's going to make it easier for the right to have a pretty radical undoing of affirmative action. And I agree with you that we're going to hear something about the time has ended, sort of like they did with, I think you mentioned, the Voting Rights Act.
Yeah.
There was a provision that they rolled back, and they basically said, "Hey, it was a great idea 20 years ago or 30 years ago, but not
Right.
necessary now." Right?
Yeah, and that's, I'm glad you brought up the point about the Asian Americans. Like, the claim here is that affirmative action is discriminating against Asians.
Right.
That's the claim in these cases. And so it's, again, I mean, it's a very clever way, I guess, to bring these cases, because they're not claiming discrimination against whites. They're using, the alleged discrimination against another minority group as sort of the basis for the claim.
Is how in these impact cases you choose a very particular plaintiff. That's a big piece of it. Okay, and it was done in many other cases. You choose a very carefully chosen plaintiff, and you shape the facts a certain way. Like I said, I mean, part of what happened here was just Harvard, was not doing what, if their system resembled what O'Connor contemplated in Grutter, it would have been a much harder case for the right, right? If they were looking at a bunch of factors and it was very amorphous and things like that, but there was just certain codes and numbers that they had that were very very hard, and they had certain, I wouldn't say pejorative, but they had certain labels that they would put on Asian Americans that were not positive and that would result in lower scores. And so it made it, I think, an easier case for the right to do what I think is, as you suggested, is inevitable. There'll be a rollback.
Well, I'm just so confused by this case, because one time Ann Coulter tweeted in response to something completely unrelated that I had said, not even to her, that I only got into Princeton because of affirmative action. And now I'm super confused, because apparently, like, Asians are discriminated against. Like, what is it? Which one is it? I have no idea.
Oh my God. That's
Anyway,
crazy.
so I blocked her after that. Anyway, so let's move on. I'll just quickly go through,
Sure.
like, just a few of the cases. So there's Biden versus Nebraska. This is the debt relief case. These are 6 states challenging the debt relief plan by the Department of Education, which is based on the HEROES Act, which was passed after 9/11, that allows the Secretary of Education to respond to a national emergency so borrowers are not worse off. They can waive or modify, quote unquote, existing provisions, loan provisions. And so Biden essentially created a plan that would forgive up to $20,000 of debt.
Right.
And the suit that the states are bringing is I think led by the state of Missouri, which is representing the Missouri Higher Ed Loan Authority, which services student loans across the country. And so there's a big standing issue here, is whether states have standing to bring suits on behalf of the loan authority. In other words, like, what's the injury to the state? So there's that whole piece. And then there's a question of whether, in forgiving this is essentially a grant that's being given to people. And is that essentially violating Congress's appropriation authority? In other words, does Biden have the authority to give a grant? And so it's kind of they're interesting, actually, legal questions. But that's, obviously a lot of people's loan forgiveness is on the hook. There's also, I think, something separate that some separate cases that are brought by individuals who essentially claim that they didn't benefit fully or at all under the criteria that Biden has. And to me, that's just like, it seems like a whiny claim. Like, I mean, isn't that true of anything? Like,
sure, I get that.
I don't
That's
know.
fair.
So that part hasn't gotten, as far as I can tell, and I think in even the arguments, it didn't get as much attention as the standing and the other parts of it.
Right.
So I think a lot of people are waiting to hear about that one. Then there's Moore versus Harper. This is the independent state legislature
That's huge.
case.
That's huge.
Yeah. I'm sure you have some thoughts on this. So this is a case about whether a state judiciary can nullify election regulations based on the state constitution. And the issue here is that the federal constitution has an elections clause, which basically gives state legislatures the power to determine the time, place, manner of elections. And so the question really is whether the judicial, I guess, any kind of judicial involvement in that is somehow a violation of the elections clause of the federal constitution.
I would frame it differently.
Okay.
And here's how I would frame it. The Constitution permits the states to run elections. They use the term state legislatures.
Yeah.
That has always been understood to be that states administer elections in accordance with state law,
Correct.
which is sort of how states do things in accordance with their own laws.
Right.
And there's a branch, a very, I would say, an aggressive right-wing reading that a lot of people on the conservative side do not agree with. Like, and Judge Ludig, I think, is one of the people who's been very very vocal about this. But basically, who against this? Basically, there's this strand that says state legislatures are effectively like executives, like full authority.
Yes.
That they're like superpowered. They can do whatever they want.
Even violate the state constitution.
Right. So if the state constitution says you have to give the state's electoral votes to whoever won the popular election, the state legislature could say, we ignore the state laws and state constitution because we, the legislature, have voted that Donald Trump should get our votes or something along those lines.
And then the state courts cannot do anything about it. That's the key.
Correct, because they're like,
in other words, no one, you can't take that to court and say that violates our the state constitution. So the issue here is a partisan gerrymander in North Carolina. And initially, the state Supreme Court, which had a Democratic, that it was barred by the state constitution and violated the guarantee to a free and fair election that was contained in the North Carolina legislature. Then, after that, people may not know this, like in states, most state judges are elected. These state Supreme Court justices were elected. After the election, there was a Republican majority on the state Supreme Court, which then reheard the case and threw out the old decision. And so, I guess there is also that issue of, you have these partisan courts, but um anyway, so that's sort of like the backdrop of what's happening there.
That's a usually important case in the long run. Not in this particular decision. It's not going
Yeah.
to move the needle. But if the independent state legislature doctrine, becomes, the law of the land and the Supreme Court blesses that, I just think it makes it easier for there to be shenanigans from state legislatures in relation to our
You
national
think?
elections. Yeah.
How, Renato?
Yeah, exactly, right. And we might invite them to the White House, for example, right? Our state legislatures. The one of the beauties of of those attempts were that there were all these other state officials and courts and so on that could be a backdrop, right? That sometimes you're going to have a state where everything lines up in a certain partisan direction and everybody in that state agrees. But the more that you have separation of powers and legal process, it gives an opportunity for you know arguments to be heard and reasonable people to hear evidence and not put a stop to something that would be very highly problematic.
Yeah. So we're definitely keeping an eye on that. And I mean, it seems like that, just to quickly dovetail that with January 6th and kind of the fake electors, it those seem a little bit separate, right? I mean, it
Hmm.
still wouldn't have allowed, like, even if a court were to embrace this, like, submitting a fake set of electors would be still illegal.
That's right, although there are certain state laws that prescribe how electors are assigned. And, obviously those state laws can be changed by legislatures anyway. But I would think without judicial review, I suppose the United States Supreme Court could still take a look at that. But I don't know. I mean,
That's not exactly a vote of confidence.
it's not exactly what I comment. So I just think that, this reading appears. I mean, there, a lot of really, smart people like Judge Ludig think that this I'd say unusual reading of the clause is not accurate. But however it turns out, I think that if the independent state legislature clause or excuse me, theory is adopted by the Supreme Court, it's a concern because the people pushing it, I think, they seem like they have an agenda to use that, yeah, for something.
Then there's an interesting case, 303 Creative versus Elenis. And this is a wedding website designer who doesn't want to make websites for same-sex couples.
Right. It's like a follow-on from the cake. Okay, yeah. Okay, same state Colorado too, right? I think if I recall correctly.
And but I think this is a
Yep.
speech issue. That was a religious freedom issue,
It was
right?
basically it was
Or maybe not.
performative. Like you were like, hey, I'm performing a service, but I don't want to perform that service or basically I don't want to sell to gay couples. This is a little different.
This is about speech. So Colorado law prohibits businesses from discriminating against LGBTQ people. And so the question is saying that this website designer has to create the website compelled speech. In other words, is it, and the website designer says, I'm not I'm not saying I don't want to make the website because of who is asking me. I'm saying that I don't want to make the website because of the message that they're asking me to create. In other words, presumably, if a heterosexual couple came and was like, love is love, like gay marriage or whatever, and that's what they wanted on their website, presumably her argument is she would say no to that.
Right. Because she's against the message, not the
Yes.
messenger. Um, I will say it rings a lot like the cake because this is the same Colorado law, but the cake case because they're similar was like, well, creating this cake is like an artistic
Mm-hmm.
expression, because you can create this and having this certain expression of having two grooms on the cake, whatever. This is much more. I will say this is much more core
Mm-hmm.
speech And just for everyone listening, the reason that it's a really thorny case is the court, general Supreme Court takes speech issues very seriously and tends to invalidate any government law that is trying to force people to say things that they don't
Yeah,
want
and
to
it
say.
is just really interesting, right? Like, in making this website, are they compelling her speech? Because, some of this was coming out in the argument, like, because the the website designer was arguing, like, you're making me invite people to celebrate this, thing that I don't agree with or whatever. But it's like she's just being instructed to design the website on behalf of this. In other words, is it really compelling her speech? I guess was one. It seemed like one of the threads that was being pulled on.
Well, one of the interesting things under the law that maybe our listeners will find interesting is that writing software code is typically seen as speech. In fact, it's copyrighted as
Interesting. Okay.
expressive. And so it's the reason why the software industry has essentially limitless or close to limitless
Immunity.
intellectual
Yeah.
property, intellectual property protection over their products. They're not like patents that expire in a fairly short period of time, and you can essentially infringe, you get a reasonable royalty. It's different in the world of copyright. And so yeah, because the idea is that somebody coding is making all these expressive choices as if they were writing a novel or something along
Mm-hmm.
those lines. So very interesting. I would also put this in the bucket of right wing impact litigation. This was a carefully chosen plaintiff by a right wing legal organization to try to move the needle on that type of
Yes,
case.
and just to bring it all home on that same theme, the last one I think that we're kind of looking out for is Merrill versus Milligan, but this is about the Voting Rights Act, um, and whether Alabama's congressional map uh, violates Section 2 of the Voting Rights Act, which prohibits denial of the right to vote based on race. And essentially, what this map dilutes, it only creates one black majority district, even though 27% of the population, um, so basically they're all packed into one district and the rest are diluted across all of the others. And I'm not an expert in kind of map drawing or whatever, but the question is sort of whether the approach to drawing district maps, I guess, needs to be race blind. In other words, whether kind of looking at the outcome of whether of kind of if it's diluting votes or packing people into a district kind of itself is violative because it is considering race. It's a little bit like, to me, it's like a weird cousin of the affirmative action case in a way. It's like kind of turning the idea of, it's using the 14th Amendment and turning it on its head by like using this idea of race blindness to allow for, I don't know, for a way that I guess discriminatory outcomes or impact.
Yeah, I mean, so I mean, just to give some background to our listeners, the Supreme Court has decided that you can engage in partisan gerrymandering all you want. So you can literally pack all the Democrats into one district where they win 100 to 1, 100 to 0 or 99 to 1, and then have all of the Republicans spread out winning 55-45 in all the other districts that create, 9 Republican districts and 1 Democratic district, even though maybe it's 60-40 in the state or something along those lines. Totally super permissible according to the United States Supreme Court. But you can't try to dilute the voting power of, let's say, Black people or Latinos or whatever, and set out to do that. The interesting thing about Alabama is that I suspect, or I don't know off the top of my head, but I believe that most, huge percentage of Democratic voters are black, and black voters in Alabama
Correct.
vote heavily Democratic. And so I imagine, without recalling the details of the specific case, that the defense is like, "Hey, we're just trying to screw the Democrats. We don't care that these people are black. We're just trying to pack all the Democrats in, and they happen to be black people." That's the right. And
Yeah, and I
so
think that
I don't know exactly how
yeah,
that's going
and
to
I
turn
think
out.
the other issue here is that and this kind of gets to the similarities with affirmative action or even abortion, is that there's pretty well established
Hmm.
jurisprudence on Section 2 of
True.
the Voting Rights Act on how it should be interpreted. So basically, the appellate court was a 3-judge panel, including 2 that were appointed by Trump, which said that it violated Section 2 of the Voting Rights Act. And the Supreme Court, in an in one of its unsigned orders, basically stayed that decision,
Hmm.
allowing the map to go into effect for the 2022 election.
Interesting. The
The congressional,
shadow
the
docket at
shadow
work.
docket. So I'm reading about this in Steve Vladek's book. And so, before ruling on the merits of the case, in other words, the merits by the way, a predominantly Republican appointed, Trump appointed panel said, based on how we have looked at cases like this before, this is a violation of the Voting Rights Act. You can't pack, all of the black voters into one and then
Hmm.
disperse them everywhere else. Um, and normally, if that's the established jurisprudence, you would not, you would allow that to stand and then hear the case on the merits. And if you're going to overturn it, right?
Right.
They stayed the decision that is actually based on established precedent and jurisprudence without giving any explanation why, allowing, this whatever new interpretation to go into effect for the last election. And then presumably, I guess they're going to now explain it. But, one has to assume that that's signaling like where they're going with this. But it is a really weird way. And it kind of gets to what he calls the shadow docket, which are ways in which they are profound. The Supreme Court is increasingly profoundly affecting the substance of the law and the outcomes that come out of it without ever explaining or taking accountability with a reasoned opinion on why they're doing that.
Which is the way that the Supreme Court has always worked. In other words, there are written decisions that set forth the reasoning of the Supreme Court, and everyone has to sign their name to those. And at times, I think, move the law in certain directions, because there's a saying, at least when I was a clerk, they'd say, "This doesn't write," and it's just something being so a contrary to the law that you just can't even write, create an opinion that makes any sense, that hold that view. And so, this allows them to sort of duck that requirement to explain themselves.
Right. It evades a really fundamental part of democracy, which is accountability, right? And we have the voting booth is the way that we hold members of Congress and the president accountable. But the way that we hold life tenure justice of the Supreme Court accountable is that we make them explain, their
Indeed.
math, like show their work, right? And I think what Steve's argument is, and I think this is an example of it, is a way in which they're not showing their work.
Right. And also a way in which they are subtly moving outcomes. I mean, in other words, it's possible they could ultimately agree with the panel below that this was violative, but there was an election that took place that
Exactly.
generated a result in the short term that was contrary to that. So Asha, obviously we're both in boring places now, but I was checking out your Instagram and I saw that you were in Princeton. which is pretty cool. At least I
Yeah.
assume it's Princeton. You're all in orange, so I
I was all
assume
in
bright
orange.
orange. I can't
It's a
imagine
little
another reason why you
insane.
wear that
Yeah.
color, unless
Yeah.
you're a snow like a traffic cone or something.
Prin- I mean, I do have a statistically improbable amount of orange in my wardrobe because
What?
whenever I see anything orange, I buy it so that I might be able to wear it to Princeton or to Princeton reunions.
There you go.
And Princeton reunions is a really interesting phenomenon. Um, you go back not just for your big like 5 years, but you go back on off years. So this was an off year reunion
Whoa.
for me. Yeah. It is apparently the largest beer consuming activity in the United States after the Indy 500.
Seriously?
Yeah.
Okay. Wow.
Yeah.
I didn't realize people in Princeton drank a lot of beer.
Yeah. Actually,
Okay.
John Stossel, when I was in college, did a 2020 on it. Um,
Okay. I
yeah. He's
remember
a
that guy.
Princeton.
It's like this like libertarian
Yeah.
guy. I remember him.
And a
Yeah.
Princeton grad. So yeah, so it's just like a crazy. I was saying to a friend of mine, a classmate of mine, that basically I think Princeton reunions are just one big psyop because they bring you back. They make you wear these ridiculous costumes or jackets, all
Mm-hmm.
orange and black. So they kind of like equalize you. It's sort of like a weird, like whatever you were at Princeton. Like now everybody looks the same, and you're wearing like you know
Sure.
some
Ugly
there's some
orange. Sure.
theme costume. I mean, they're literally costumes
Okay.
or jackets, and so you're all the same and you're all ridiculous, and then you basically like drink a lot, and so over time your memories of time at Princeton like sort of get a little hazy, and you just remember your times like dancing under and the bands and stuff. So the reunions themselves like have all these entertainment options. They've tried to tone it back, but several years ago the 25th reunion, for example, had Bon Jovi.
Whoa.
Yeah.
And for New Jersey, that's
Right, like
like
what, like
Christ himself
they've had
came
like
down to play
Joan
guitar.
Jett and the Blackhearts, and they've had the
That's
Beach Boys
cool.
come back, and like I mean Duran
All
Duran has
right.
got like, so they've tried to tamp down on the big bands because it's creative security issues, but like you party, you dance, you meet people, it's like all fun, and so like over time, like 25 years later, when they hit you up for money, you're like, Princeton is amazing, and it was amazing. But like at this point, I remember more my time at reunions and connecting with people than I really do like what I was doing exactly like as an undergrad.
Oh, your
So
brain cells have been
your
destroyed
brain
by
cells have been
alcohol.
destroyed. Yeah, it's brilliant. It is truly brilliant. It's like the, best alumni giving strategy. And when I was at Yale Law
Wow.
School, I tried to convince them of this. I was like, you guys bring these people back and like put on these panels
They
for
do.
like three
It's like a bunch
days.
of scholarly claptrap for a few days.
And I was like,
Yes.
no one wants to go to panels. Like, or have a few panels, but then like, so actually one of the earliest times, one of my earliest years at Yale Law School for the alumni weekend, I convinced them to do a casino night.
Oh, that's awesome.
Yeah, it was
I
really
love that.
fun. It was really fun.
That sounds like
Casino
fun.
night with like swing dancing and
Sweet.
yeah,
Swing dancing, but okay.
what?
Casino night.
Swing dancing
Swing dancing.
well, like a swing
Asha.
band.
Oh, okay. Okay.
A swing
That's fine.
band.
I don't know swing dancing, but okay.
I mean, you don't need to know swing dancing. You can do
You
like a
just get
box
drunk
step,
and
right?
dance.
You can do a
Okay.
box
Yeah.
step.
Got it. Okay.
Yeah.
I think that's cool. It's way cooler. I went to my 25th year. This year I went to my 25th college reunion at the University of Chicago.
Mm-hmm. Was
And
it panels?
no, it was just like a dinner. There's like a bunch of activities all weekend long that are not class specific. And
Okay.
so like they're just like different fun-ish stuff. Although they had a lot of panels. Like Jonathan Turley came and speak. I did not
My
catch
God.
that.
Are you serious?
True story. I'm like, they actually gave that guy a podium. So no interest in that, but a lot of different panels and stuff and beer gardens and whatever. But I went to the class dinner and it was like, of our class of, 800, 900 people, there was like 50 people there, and it was just like,
Really?
whatever. Yeah.
Okay.
It was very, and my Yale 20th year reunion was during the pandemic. So we had a
I
Zoom, and
know.
then they never made it
Same
up.
here, because I was a class ahead of you.
Yeah,
Yeah,
they
mine
didn't
was
make it up
2020.
for us.
No.
They did, and they didn't message it very well either. They basically where it was like a secret thing. Like they told us they were going to make it up, and then when the year came by, a bunch of us asked, like, "So are we doing it this year? Are we making it up?" And they're like, "We don't have enough space. Sorry."
Let me tell you, and I know I work at Yale, but I no longer work at the Yale Law School. And so I'm speaking as an alumna. Yale Law School reunions are terrible. I'm sorry, but they suck.
This is an extra long episode because we have a lot of strong opinions about reunions.
Yeah.
Okay, I can't wait to hear. You got to explain this now. And
I just think it's
they are
terrible.
gonna.
Like I said, like I literally had to convince them to do something fun. And they did it, and it was like so outside their comfort zone, they reverted back. I mean, one year, I think when we were there, they did like a moot court with Hamlet. Like they brought.
Oh
Do you remember this? Like because
no, but that's
I
cool.
had produced the Merchant of Venice in the law school courtyard, and so inspired by that, they had like a scene of Hamlet, and then they brought in some. They did basically a moot court. They brought in some judges, and they had like David Kendall and I forget who else argue like whether Hamlet should be convicted of murder or something like that. So something
Okay,
fun. Like it was kind of goofy, but also like fun.
yeah.
So if you're gonna be dorky, like just do something fun. But they can't do it. It's just a disaster. I'm
Yale
sorry.
Law
And it's
School
super
reunions are basically
expensive.
a bunch of panels. A
I
bunch of
don't go
panels.
back to Yale Law School reunions. And I
Well,
literally
you're
work
there
at Yale.
already.
I know. I went when I was in I went when I worked at the law school and it was free, but like I'm just like, yeah, I don't know.
Wow, I like going back to see all my old friends and stuff. It was a great time in my life. The panels are just whatever. I view them as like they're trying to like networking opportunities. It's just very serious.
Too serious.
A little serious, but whatever. It is
They
what
need
it is.
fun. They need karaoke.
I agree.
I'm telling you, if I were in charge of Yale Law School reunions, giving would go like attendance would go up, giving would go up.
You know,
It would be
would you
a
do it
great
at?
time.
Do you even need to do it at Yale? If you want to make it really fun, go out on a cruise ship or something. We
Totally.
could have like instead of the
Totally.
Love Boat, the Yale boat. We'll
Yeah,
just
the
sort
Yale
of,
boat. Totally.
unlimited drinks, and we could have a casino on the boat and
This is what I'm talking
entertainment.
about.
There
Thank
you go.
you, Renato. You're seeing my vision.
There we go.
MSW Media.